Great. So yeah, feel free if you have spouses that are jumping on, kick them over the Zoom link. That'll be great. We will have it recorded. My hope would be that this is the beginning of many more conversations, not the end. I want to first give a huge shout out to Ty, who's coming to share with us on the topic of estate planning. This is something that I think as parents in particular, it's kind of always in the back of our minds. We know we need to do it. It's super important. As you start racking up kids on your dependencies, you start to, it feels the weight continues to grow. I know many of us have, very different family situations and need even more assistance, both in life and, in the undesirable event of our demise. And so my hope is this year, really for all of us, that we just start to lean into this need. And personally, I think if I had a big insecurity around estate planning, it's like, I don't even know what I don't know. And if there's one really healthy habit I've learned from News Story, it is that the first instinct when you don't know something is go find really knowledgeable people and get them to brain dump everything that they know about what's important and what's not. Fortunately, we have somebody on our team who married well. And so Ty is Megan's husband, who all of you know. And so very familiar with the topic. He's going to give you probably some disclaimers around things in his state and how he can't help most of us actually do the filing. But fortunately, a lot of the things he's going to talk about today are relevant to us. And then for those that have done none of this prep, my hope would be that you take something away that you could start doing. And then for those that have done a bunch of this before, I'd love your experience and insight as well. If you have questions, just drop them into the chat, and Ty's going to present for a little bit, and then we'll shift into some Q&A. So if you're thinking about it, type it into the chat. That'll be great. It is being recorded, so if you want to share with a spouse or come back and rewatch, we can do it. And with all that behind us, Ty, I will let you take it away. We're super grateful to have you, and thanks for putting all this together.
Hey, well, thanks for having me. I love. I'm an estate planning attorney. I love what I do, and so even if I wasn't married to Megan, who's part of your wonderful organization, and if Morgan had reached out to me, I would have said sure. Too many young folks have not even begun to engage in this process, and usually that's not a critical problem because young people don't die every day, but they can, and so this is important for all of us to have in place. You'll probably realize by the time we get to the end of this hour, or whatever it may be, how surprising it is how few people that you will talk to have any concept of what we'll be talking about. From a legal disclaimer side, I actually hadn't really thought about that until Morgan pointed it out. I'm an estate planning attorney from Pennsylvania, and specifically an estate planning from Pennsylvania, or an estate planning attorney from Pennsylvania, who mostly serves people whose total wealth is below about $2 million, all said and done. I do serve a handful of clients over $20 million. So we're gonna, but my focus is honestly people who are not federally taxable. And so if you're sitting down at this and you have more than about $20 million in wealth, you probably already have an attorney who helps you out with some of these questions. But just be thoughtful about kind of your niche here. $2 million and below is actually a really good band of wealth because it applies to folks in our neck of the woods, which is Western Pennsylvania, kind of a lower wealth area. But that level of wealth tends to coincide with people who are building wealth, people who are under 40, under 50, still kind of growing before bigger wealth might happen. The concepts I'm going to cover today are pretty general and should help anyone really level up their understanding considerably. But they are state specific. And so there are some things that I might tell you that once you talk to an attorney in your specific state might differ just slightly. I'll try to point those out as we go through. Also, I'll be checking the chat as we go through, and Morgan will as well. Please don't hesitate, interrupt me like that. This is what I do for a living. You're not going to knock me off track. I think I've timed this out for just about 30 to 40 minutes, but I plan to hang around for questions after. I also plan to be happy to answer questions as we go through. This is kind of new material for me, which is exciting for me because most of Most of the people who come into this office are over the age of 65 years old, and our firm is trying to make an effort to bring in some younger professionals for their estate planning. And so you'll see a lot of concepts here that are really targeted towards people who are building families, have families, building wealth, and need to figure out what to do to make sure that goes to the right places. So without further ado, really you serve yourself well when you think about estate planning by actually starting and keeping it pretty simple. Nothing we're going to talk about is going to go over your head. But generally speaking, when you focus on the things we are, two goals: health, wealth. Wealth being kind of the big one. We want to make sure your assets, if you were to die, go to the right people. It's a simple, it's a simple concept. On the health side, the non-financial side, two biggies, and maybe the one being the bigger of the two. We want to make sure that if you have children for whom you are responsible, that you're able to name guardians for them. It's pretty basic, but it's one of the good reasons to have a will if you have children. And obviously, we encourage even young people who are doing wills to get themselves a healthcare power of attorney done at the same time. That's a non-dispositional sort of thing. But if you go to get a will, get a healthcare power of attorney, make sure your spouse or your significant other, especially if you're a non-married cohabitating situation, you really need that healthcare power of attorney in place to ensure the correct surrogate decision makers in place in case you were under anesthesia or you were in a coma, any number of things. So think of it as a health wealth sort of dichotomy as you're going through this. The simplest thing, and I put it first here because if you don't remember anything about what we've talked about today, the rule of SJB. And if you understand this, if you could master this, you probably could be an estate planning attorney, because it is the most straightforward way to understand wealth ownership. Believe it or not, there are really only three ways that you can own any given asset. You can own it solely, just in your name. You can own it jointly with another person or persons, and you can own an asset that contains a beneficiary designation. Because you all are young professionals, a lot of your assets are going to fall into that beneficiary designated category. Your IRA, your life insurance, certain accounts that like investment accounts that permit the naming of beneficiaries. These are really critical. The good news is estate planning for young people is actually not very complex and not very expensive. But the key piece is that as we have moved to more of a, and you'll understand this word by the time we're done, more of a non-probate sort of society, it's put more of the burden on you as the estate planning, or as the end user of estate planning. So I've given some of this out here. The way in which you own a given asset, solely, jointly, or with a beneficiary designation, that is what dictates what happens to that asset when you die. That is it. And I can't say it enough. That's the yin and the yang, S, J, and B. Generally speaking, if you own it jointly with another person, especially if it is titled jointly with another person, it's going to pass to that surviving person upon your death. That's why if you happen to be married and a lot of your assets are owned jointly, a good part of the time they're going to pass sort of automatically to your surviving spouse. In a lot of people's cases, and we're going to get into making your assets list here in the next slide or two, you might make an entire asset list for every single thing that you own, and you might only have J and B sort of assets, jointly owned with my spouse, or it has a beneficiary designation. You might not find a lot of S's, and that's a good thing. If S's, as you'll see, kind of cause us a little bit of trouble. But we spend all this time talking about wills. The only assets of yours that will be governed by your will, let's say you had a will right now, the only assets that will be governed by a will are going to be assets which you own solely, that do not otherwise have a beneficiary designation. I'm going to pause for just a moment. If you're married, do you have to state jointly, or is it implied? Really good question. Probably depends a little bit on the context of the actual asset, as well as the state in which it occurs. Generally speaking, if you put, I'll use real estate as an example. I own my house, Ty Cressman and Megan Cressman, husband and wife or as spouses. If we do that, we have created in Pennsylvania even something actually more powerful than joint ownership. It's what we call a tenancy by the entirety of property. Spousal ownership in most states is favored, like there might be certain creditor protections and so forth. And so, but generally speaking, if you have me and my spouse, comma, as spouses, it's going to sort of impliedly create that joint ownership. Again, context specific most of the time. And using a simple example, let's say your checking account is Ty and Megan Cressman. I've probably titled that jointly. I probably, when I opened that account at ABC Bank, I probably had to sign the signature card, and so did my spouse, and that's what made it a joint asset at that point. So you want to, it's asset specific in that consideration, and that's an important one. Where you see a lot of not mistakes per se, but a lot of times I go out and purchase a car, my spouse is not with me, it's a solely owned asset, my automobile. That's usually less of a big deal, but it's another one that's nice to clean up, retitling, making sure your assets are jointly owned with your spouse, if you have a spouse, is a big deal. The biggest of big deals, I would say, are beneficiary designations, because getting them wrong can have really costly problems. So the number one thing we're going to touch on again and again today is that for assets that permit you to name a beneficiary designation, you got to make sure your beneficiary designations are correct. But again, SJB, it's all that we do all day. Here is
I
Sure.
have a question real quick before we move on. When you're saying where the asset is, that designation, is that done on the actual, like, I know for a car, it can be done like on the title of the car itself. But is this just like, in the event of other things that can be jointly owned, is that a declaration that is done in your will, or is that specifically on the like purchase agreement of that asset? Where is that stated?
Closer to the latter of those, the purchase agreement. So cars have titles, real estate has deeds. Bank accounts typically have signature cards or other sort of underlying documents. So think of that joint ownership as being created at the source, so to speak. Your will could not create a joint asset.
Got it. Last question. I think for some people, I don't know, everybody's been kind of married for different lengths. Here, I know for me, when I got married, I brought my wife into my credit or my checking account. I don't think who owns that? I know she has access, obviously, but like, is it, if they have access, then it's implied joint ownership, or no, that would be a separate, like, go back to the bank, they're going to sit you down, talk to you off for an hour, and then you're going to ultimately sign another sheet of paper.
Closer to the latter of those. And so it is, when you've had assets, it's easy for some of us who have been married since they were very young. A lot of your assets kind of grow up together. They're joint from the get-go. The later in life you get married, the more you run into this specific issue. And think of the distinction as one between access and ownership. So in the example Morgan gave, he said, well, I had a bank account. My spouse can write checks or can do other things like that. But she probably, or he or she may have access, but not ownership. And that is something usually you have to go to the bank and really hammer home this question of, because they'll always try to say, well, your spouse has access. That's good enough, because it's a pain in the neck to retitle an account. And they might even have to open a new account in those cases. And so you really have to hammer the kind of the customer service person to say, no, my investment account with Edward Jones, I need it to be jointly owned, et cetera. And I would say to Shane's question, we're going to get to that question of what happens to a joint asset if you both pass. As you'll see when we talk about these, joint assets ultimately become solely owned assets. Typically, I die, now my spouse owns it solely, and then let's say she dies, then it's governed by a will. And so there is a progression that goes along. I want to answer Annie's question here with real estate. If my name is on the loan, but Rudy and Annie is on the title. Is that considered joint ownership? So you do see this creep up once in a while. I did a real estate transaction a couple weeks ago where it does feel like it's better for one party than the other, where you might have two people as joint owners on the deed for property, but the loan might only be in one name, etc. The loan, and the reason banks are willing to do that is because their security secures the property. They're not going to get cut out of the situation no matter what. But the important point being, it's the deed. In the case of real estate, the deed dictates ownership, just like underlying signature card of a bank account or an investment account dictates ownership. Sometimes you can get around that with investment accounts. Let's say I had an Edward Jones investment account prior to me and my spouse being married. I don't feel like opening a new account and jumping through the hoops. I could also get around this by simply naming my spouse as a primary beneficiary of that account. Now, I might not get some of the nice spousal protections that might be offered in my state. So generally speaking, if I'm married and if my estate plan dictates everything is to go to my spouse, then I'm going to want to probably have that in joint names. It's just a better way to do things most of the time. So what's yours is mine, and then yes, very, very good. And this is worth spending, I appreciate these questions because this is the most important thing we'll talk about. This is the yin and the yang. And if you wanted to, and I'll circle back to this in my last kind of next steps for everyone, but if you wanted to do the most valuable estate planning you could possibly do, and you can do it you can do it right now while we're on this video, but you can also do it the minute we get done. Make this list, the sample that I've given to you, because honestly, this is all a halfway decent estate planning attorney is going to do when they have you in the office is let's talk about your assets and let's talk about how they are owned, because the way in which they are owned is going to dictate where they go if you die. It's actually not that complex, when you get down to it. The key is usually actually figuring out what we own jointly versus solely. Any questions? I want to pause for just a moment, but this is the sort of list I have people make when they come into the office, is sort of as we get started, and not because I actually care how much they own. Typically, no one in our neck of the woods, or very few people, are federally taxable, and so I don't need to do a lot of that analysis most days of the week. But this is ultimately deciding kind of what's going to be affected by what. What happens upon the death of spouse number one versus spouse number two?
I have a question about this. It's really more of like what could potentially be a line item, but I know for many people on this call, we may have an LLC or a business that is not jointly owned. It is owned by just us. Mm-hmm. And, in the category of things I lose sleep over, it's that something happens and now clients and people from this area of my life that my wife has really no understanding or access to, come calling. Mm-hmm. How would you think about that compared, because it is still an asset, and if it's there, maybe it's independently owned or owned with a partner, but how would we think about classifying that asset, obviously valuing it, and then figuring out what happens from there, other than just like an operating agreement?
Yeah, businesses are a real challenge in estate planning. And let's use the example first of it's a sole proprietorship. I own a small entity. It's a web company. I started to do things for myself. I formed it as an LLC. I own 100% of its ownership. Making sure your spouse or your executor kind of knows that you own that, what's going on with it is kind of on you, so to speak, because there's no one else who will be able to take care of that. And that's something real to consider. As you think of putting together kind of that death file, so to speak, in the perfect world, we all have this nice little 5-inch sort of accordion folder that has some subfolders to it. And in one is your will, and one is your powers of attorney, and another are the sheets proving the beneficiary designations for certain non-probate assets. And again, we'll talk about this again, maybe in another folder is something regarding my funeral arrangements if I've desired to do them in advance. But if I have a business, then in one of those folders is going to have some information relating to the business. And I'm going to have to be providing to my spouse, or at least having somewhere available access to some business stuff. Now, if I die, my spouse isn't going to be entirely, hopefully, on his or her own. Hopefully I did my taxes with maybe I did my taxes with a CPA. The CPA can help pick up the pieces. Maybe there's a financial, person, but for small businesses, the owner dies, the business dies is usually the way it goes for these exact reasons. Like there's no one to carry it on. With a partner, sometimes it's actually a bigger deal in a different way because you have potentially adverse parties to your own spouse involved. And that buy-sell agreement sort of that you have in place is going to dictate quite a few things. Usually your half, your portion of that business is going to pass, according to your will, because your ownership is your part of it's a solely owned asset, subject to the conditions of your buy-sell agreement. Maybe there's key man insurance or key person insurance that kind of handles some things. But again, a separate subfolder there, especially if your partners are, it's one thing, they're different levels of partners that you deal with. So I don't know if I answered. Morgan, did I answer?
No, that's great. I think if anything, so I have some key bullet points, and then I think maybe the bigger flag that I have is we probably need to do another talk just on that topic because there's a lot of nuance there. And I think if I'm doing quick math on the call, I think we're like 50-50 of people I know that have something on this, like something else, and then the other people I just don't know. So it feels like a big enough category that especially like buy-sell agreement, key man insurance, and some of those things are one, I think great things entrepreneurs should have, and also similar to estate planning, they might not.
It is, I'll tell you, the number of business folks running around without those is big. And there are some quick fixes and some, more expensive fixes to those situations. And you're right, it kind of has its own sort of subspecialty there. I take a quick look at the, okay. So think about, I start to bring in some terminology here that is, one of my hopes is that you actually have a pretty good feel for what these words mean by the time that we are done today. Really, two types of your wealth from an inheritance standpoint is going to fall into one of two categories, either probate assets or non-probate. And you can see, we'll start to make some of these distinctions. If it is a probate asset, it's going to be controlled by your will. Non-probate assets tend to be controlled by something else, including beneficiary designations most often, or joint ownership. In the case of my spouse and I own real estate, that's going to be a non-probate asset when I die. And we are going to get into what these terms mean, I promise, so you have a feel for it. Maybe as I went along, I thought there was maybe a better way to represent this information. And so again, think of solely owned assets are being subject to probate as opposed to certain. And again, always consider that there's an asterisk next to jointly owned, because as we've talked about, joint ownership doesn't always mean survivorship the way it's being used here. So I'm using jointly owned in a pretty classical marital sense where you and your spouse own an account jointly, or you and your spouse own real estate jointly. Now, you don't have to be spouses to create joint ownership like that. You don't have to be married, but that's the way when I say jointly, that's what I'm implying there. Beneficiary designated assets, again, naming a beneficiary, pretty straightforward there. Non-probate is pretty straightforward. It means that ultimately those assets are going to be controlled by the beneficiary designations or passed to the surviving owner. Solely owned is going to be controlled by your will. Think of the issue with solely owned assets, those S assets, is that there's no one else to automatically receive them. And so your will has to kind of kick in as a backstop to direct where they go. You need the instruction list to direct where they go. Jointly owned, if there's a survivorship presumption, ultimately it passes to the surviving owner. Beneficiary designated, we have essentially contractually dictated who's going to be the recipient of that asset when you die. So I talk here about probate, one of the more misunderstood legal words that is commonly used. And so hopefully you're able to come out of this understanding that it ends up getting used in a bunch of different ways, which is why it's very confusing. Generally speaking, it's the process of admitting a person's will to the court system. Basically, Carl dies, I'm his executor, I walk his will into court. You're welcome, Annie. Ultimately, it's then subject to the jurisdiction of that court system. It's the probate process is how you often hear that used. When I do that, it means that the assets, the solely owned assets that are going to be governed by my will are going to be subject to the rules of that court system. That's part of the reason we like non-probate assets, because they pass, as we'll see, they pass directly to my beneficiaries without some of the influence and interference of the court system. So non-probate's generally speaking a good thing.
If I were to on the non-probate side, it's the equivalent of, if I wholly own my computer and then I die, well, then my wife now has the computer, and it's pretty clean and simple. Is that an equivalent of a non-probate, the value of a non-probate process? Is that it kind of not informally passes because there is a formal backing, right? But the asset kind of just changes hands, and it's one less thing that you have to stress about dealing with, and it's kind of that implied possession and ownership.
So I think, and the best example, and the one that is most common to most of us, probably most people on this phone call have an IRA or a 401k with their current or former employer. Think of it as actually a pretty explicit contractual process where, but it's a direct process that is specific to that given asset. Whereas your will is like this kind of backstop. It basically says, everything which I own goes to A and B and C. Non-probate ownership is an asset-specific direction as to what happens to that asset when you die. And so IRA beneficiary designations are the best example. Life insurance is another example. Life insurance has had this figured out 100 years ago. We, as a society, have come up with more and more non-probate sort of assets over time, and more ways to make assets non-probate, but it used to be just life insurance. You also see the word probate used when talking about kind of in a verb form or whatever, and in that context it's meaning the same thing. It means someone's just essentially taking the will to the court for it to be admitted to that probate process. And usually people don't use probate in a particularly friendly way or a particularly positive way. They talk about avoiding probate. They talk about not wanting probate. And that's simply because, just like we talked about, the most efficient passage of wealth is directly from you to a beneficiary. Non-probate ownership allows that to happen, like in the example of your IRA, your 401k, or your life insurance. In the case of probate, it means that it's ultimately subject to a variety of procedures. And I talk about that a little bit here. In the probate process, ultimately, let's say, we'll use me. Let's say I die, I have a checking account with $100,000, and I have an IRA that's $100,000. And my IRA names a beneficiary. So for my bank account that just is owned solely by me, an executor will have to be appointed by the court, will have to go to that bank, get the bank account, open an estate account, move it over to the estate account, and then ultimately pay my creditors, if I have any creditors, pay any sort of court fees, and comply with any other rules of the local jurisdiction. It's a process, which is why it's called the probate process. Compare that to my IRA, which named a beneficiary. It's going to pass. Now, we might have to provide proof of my death, but ultimately it's going to pass directly to the person who is named with that company, the name that they have on file. That is why non-probate ownership is generally the ideal ownership. I'm going to pause for just a moment. Anybody have any questions about that? All right, since we've kind of ideally mastered this kind of preliminary concepts, solely owned, jointly owned, beneficiary designated, how they kind of interact with probate and non-probate pieces, I'm going to talk a little bit about the actual people who are inheriting beneficiaries. Obviously, beneficiaries who are able and eligible to inherit money today are pretty easy. Using the example of your IRA, let's say I name my spouse as my primary beneficiary for 100%. And if my spouse predeceases me, I name as a secondary beneficiary my brother, who is also fully able to inherit. No problems in that equation. However, if I have, let's say my secondary beneficiaries would be my children who are young, they can't inherit property yet. Or I have a child or someone else who is a disabled beneficiary who's receiving means tested benefits, who may never be able to manage money. Well, that's a problem. Let's say I want to leave it to my brother, but my brother has spending issues, my brother has substance abuse issues. You know, there are a host of things where we have beneficiaries who cannot inherit outright. And so I call these, problem beneficiaries because I didn't have the time preparing this earlier today to think too hard about what to call them. I wouldn't call them that to a client, but ultimately these beneficiaries can't inherit outright. Where this comes up and why this is critical is that many of the assets you probably own are non-probate in nature. So you can name direct beneficiaries in your IRA and your life insurance and even most of your investment accounts. But the issue for young professionals is I'm starting to accumulate kids, let's say, and they can't inherit just yet. So how do we solve that problem? Solving that problem ultimately involves talking a little bit about trusts, which is a new concept, and again, a kind of an arbitrary, misunderstood concept in some cases. I think it helps to compare them to what your will does and doesn't do. Think of your will. The best image I can give you is of a to-do list that your spouse, puts on the refrigerator. Your to-do list, because wills, they can be complex, but at the end of the day, they're not that complex in most cases. Think of it as a distribution mechanism. I want all my assets to go here or there or anywhere. And your will only affects assets that you own at the time of death. It is I call it a time one sort of instrument. It's just simple. If I own the following assets at death, here's where the following assets go. The executor is the person that I put in charge of carrying out those wishes. Think of it as an instruction list. Trusts, they are an entity. So it's the difference between an instruction list and an actual entity. Trusts operate through time. And so they can do different things at different times, whereas my will really only has impact upon my death. Instead of an executor in a trust situation, we have a trustee. So trusts are really helpful if I have beneficiaries who cannot inherit today, but who I want to inherit tomorrow at some future time. I need this sort of entity. So wills versus trusts in a nutshell. Now, giving you some practical guidance, here's what many people do in their wills. If you have young beneficiaries, you can actually use your wills to create trusts. I'm going to take a break for a minute to ask Morgan's question. When I say own at the time of death, do you mean wholly own? Really, good question for just a moment. Generally speaking, I mean anything that I solely own at the time of death is going to be governed by my will. So my real estate, if I solely own it, my car, if I solely own it, bank account, if I solely own it. But Morgan's question actually invites an additional concept, which is in the case of a mortgage on real estate, what I'd call sort of a conditional you could think of mortgages, by the way, as a sort of conditional ownership. Like I genuinely, if I own my house and I have a mortgage, I do own my house, but it's conditioned on me paying my mortgage, all the way through. That can be kind of yanked from me. So for purposes of my last will and testament, I do own my house, and my estate owns my house after I die. My executor has to figure out how to pay my mortgage, which is part of the reason, guys, that we don't like non-probate assets becoming part of your estate. We're going to talk about that because your estate is subject to your creditors. My student loans, my mortgage, someone who I might have killed in the car crash where I died, whatever it may be, those creditors can go after my probate assets. My estate is the embodiment of me after I die. My non-probate assets, the goal is to get them to pass outside of probate because I don't want to mix those two things. The best example I can give you is kind of in Ghostbusters. They talk about not crossing the streams of their lasers or whatever they are. That is probate and non-probate. We want to keep those streams, generally speaking, separate. And so it's that powerful. Not that the world is going to blow up if your probate and non-probate get together, but it's not good, as we'll talk about some negative situations there. Thank you. But you can use your will to create these trusts that you need. And this is a pretty common format for people who have children. Let's say I draw the simplest will. And again, we could do this on a notepad while we're talking today. I leave everything to my spouse. If my spouse has predeceased me, or if we die at the same time, then I leave everything to our 3 children. However, in the paragraph below that, if any share shall pass to a beneficiary under the age of 25 years old, then that beneficiary's share is held by someone else for the benefit of my children. Those words, or any words really like them, create a fiduciary relationship or a trust sort of format. In other words, I am putting someone else in charge of the property for someone else, or for the beneficiary. I call this a testamentary trust because it is a trust that is created by my last will and testament. The language in my will creates a trust, and the language in my will ultimately dictates the terms of those trusts. Here I gave the example, my beneficiary's share will be held by Tom as the trustee. Tom has the discretion to make distributions for the health, education, maintenance, or support of those beneficiaries. So Tom has some discretion, and it looks like this trust terminates once my beneficiaries individually reach the age of 25. Again, it's pretty slight on trust mechanics, but ideally the language of your will would be much lengthier with that. The big takeaway here sure.
No, go ahead. I didn't.
Oh, just
yeah.
The quick takeaway is that these trust relationships can be created by your will. So go right ahead.
This is a little nuanced in what you shared. So it implies a fiduciary responsibility, or it actually creates it. Meaning, let's say with Tom, because I put it in my will, is now Tom bound as a fiduciary, or it's implying that has been established somewhere else? Like, because so fiduciary, like this person has to act in the best interest, right, of what's been stated. Not everybody, that's not assumed, right, in any relationship. So like Nathan, he and I don't have a fiduciary responsibility. However, we could enter into one. Are you saying because I put it in my will, it creates it, or it's just like implying that has been established somewhere else? Does my question make sense?
It does. Trusts can be created very easily. Pretty much any time I use the words, and I could actually, so in Pennsylvania, oral trusts are not permitted, but let's say I'm in California and they do. I could say, Morgan, I would like you to hold this watch for the benefit of Megan Cressman, and if I don't return from Antarctica, I want you to give it to her. We have technically created a trust relationship, and as long as you accept the watch, you have accepted that kind of fiduciary responsibility. I can't bind you to it. And so by simply naming Tom here, I haven't conscripted Tom into being a trustee, but as soon as he accepts the money from my executor, he's going to be in that fiduciary sort of responsibility. So I mean, even fairly careless drafting could create a trust relationship, because basically I've used the words for the benefit of somebody else. And in order to evoke or bring in any sort of separate trust, any sort of separate document, to the extent that's what you meant, I would have had to kind of explicitly, and we'll do this actually in the next slide, but you'll have to explicitly reference that other trust, if that makes sense.
Yeah, I think part of why I asked, like in the United States, most executive team members are viewed as fiduciaries for the company. So because I took the title, congratulations, this is implied, right? So I can't point to a document that says that, but I can point to a job title that holds me accountable to that standard. And I'm wondering, like, is the same true? It sounds like the answer is no. That fiduciary responsibility would have to be established unless it's in a state that accepts oral. Well, I guess this would be written. So if it is written here, is Tom on the hook or not? Because Tom may or may not have known that I wrote him into this, right? Is he on the hook as my fiduciary?
Tom is not on the hook until he accepts the money in agreeing to carry it. And so in the example of, you watching over the watch for Megan while I'm in Antarctica, as soon as you accept the watch, you're bound. But kind of speaking to what you said, trustees do have a whole host of implied duties that are established by state law. And so the minute Morgan accepts the watch, promising to watch it for Ty for the benefit of Megan, he has, duty of confidentiality, duty of, care, duty of let's say, I don't do a whole lot of fiduciary litigation, duty of following the best interests of the beneficiary, all of those sort of implied duties that I think you were referencing kind of in your discussion there. So
that's super helpful.
Trusts can also be created or can be standalone documents that exist outside of your will. Generally speaking, for young professionals, this is how I like to see them structured for a couple of reasons. And it actually all comes back to that Ghostbusters thing. But ultimately, option 2, and again, you can go either way. Think of it as option 1, option 2 for most young professionals. The other example is I have a will that does not contain any trust provisions, but simply distributes the assets that I own at death to a standalone trust, typically a revocable living trust here. I like doing it this way because actually for a host of reasons I can get into. But ultimately I have a separate trust document that does trust stuff. Usually I don't like my wills to be very long. Also, my will is a matter of public record. It gets recorded filed at the courthouse when I die. So I don't like, your trust doesn't have to be public in the same way. But the more important part is that your will simply distributes the assets of your estate to the trust. And again, in a simple example, my will might still say, upon my death, I leave everything to Megan Cressman. If Megan Cressman has predeceased me, or if we die at the same time, then my will shall distribute all assets to the Cressman Family Trust. And that could be it. That could really be the operation. So 2 ways you can set this up, and probably depending on your state or the lawyer you choose, he or she might have a preference as to how they do that. This is where it gets critical. And so since most of the assets you probably own, not certain, but probably as young people, your IRA, 401k, life insurance, etc., those non-probate assets, usually you have to do some coordination with trusts if you have children in your estate plan. Again, I use the example in the middle of the page from my IRA. My primary beneficiary is Megan, 100%. My secondary beneficiary probably should be the trustee of the Cressman Family Living Trust, dated, whatever it may be. That is the key here. And what you don't want to have happen, and I put it right at the bottom because this is one of the more painful and expensive mistakes I see taking place, do not allow qualified retirement assets to pass either by default or because you just chose my estate as a beneficiary to your probate estate. It just causes a variety of painful tax consequences that are worth avoiding. Any questions on this? I want to make sure I get to all of the material, but this is a biggie here, the coordination between these things. So to the extent, I kind of drew up some sample sort of estate planning slides, and you'll have to kind of forgive my sort of basic abilities here. I tried to talk about this being used as a, kind of in that we talked about a testamentary trust, option 1. So you imagine, and again, this was the question Shane asked early on as well. If I have a jointly owned asset and both of us die at the same time, what happens? Generally speaking, it will default to the estate of one of you and be governed by one of your wills. That's a very state-specific sort of mechanism. But generally speaking, me and my spouse, we own our real estate. I die, Megan owns it solely, and then it's governed by Megan's will, unless she takes some sort of other ownership action. So imagine your probate estate over here in white. One spouse has died, the other spouse then dies. Your real estate, checking, savings, automobiles will all become part of your estate, which is governed by your will. Your will, let's say you're aware that you have minor children, you want to protect them. So your will actually creates a trust of some sorts. This is actually a little bit mislabeled. Instead of a revocable living trust, I would rather see this just say trust. So the trust language is embedded in your will. Now, done right, if you choose this sort of estate planning approach, your non-probate assets will name, let's say your spouse is the primary beneficiary, and they will name this trust created by your will as the secondary beneficiary of these assets. Really important, because we don't want that IRA to go to your estate. We don't want the 401k to go to your estate, but they can go to the trust or the trustee that is created by your will. And that's what I mean by keeping the streams sort of separate. We want those non-probate assets to pass only to the trustee of that trust, even if that trust is created by your will. So really, really critical stuff. Here's my preferred format. Frankly, you'll see on the right, we have a revocable living trust. We just straight up name that revocable living trust as the secondary beneficiary after my spouse to all of my non-probate assets. Ultimately, any probate assets would pass by way of my estate to my will, and my will is what we call a pour-over will. It just directs all of my assets, just dump into my revocable living trust, and now management for my children can ultimately be handled through that mechanism. This is what I would consider for a young professional, probably the more optimal way to do this. It's just an easier way to do it, in my opinion. Any questions? Is that clear? I know this is not very complex, but anyway.
I think I'm struggling. So, and you said this, I'm just struggling to piece it together. The revocable living trust. So it sounds like when you're saying that the trust that is established in the will is really just like a declaration of intent almost, right? It's not like an LLC where I go to the courthouse, I create this thing and it lives in a file cabinet in a government office. Is that correct? And then like the revocable living trust is more like which of them is actually like a formal thing that would have some documents that you could have keys to?
This second option is it's a separate standalone document that you've executed, and it can just be a series of pages, but it is a separate document and a separate entity that is created while you are alive. Compare that to, and again, this should not say RLT at the bottom, it could just say trust. Ultimately, think of a testamentary trust as a paragraph of, could be as small as a paragraph of your will that says anything passing to a beneficiary under the age of 25 will be held by Tom for the benefit of those young beneficiaries. And now it becomes a separate entity, so to speak, after you die, and upon the conclusion of administration of your estate. but it's not a standalone entity in any way, shape, or form while you're alive.
Well, and even it sounds like when you're saying it becomes a standalone entity, we're talking about like the abstract form of an entity, right? Where there's like commitments and there's liabilities and things like that. But it's not like Tom now has to go to the courthouse and establish this thing, or is it like it? No, it literally converts into something that there's government paperwork that you have to renew and sign up for.
So Tom does. So think of it as in this example where that trust paragraph is embedded in your will. During the administration of your estate by the executor, Tom doesn't have much to do. But upon that conclusion of your estate administration process, and let's say the executor, Jane, hands over to Tom, here's a check for the entire balance of the estate. Tom goes to ABC Bank and deposits that into a bank account. Then at that moment, then it becomes its own taxable entity. Tom will have to obtain a tax identification number for the trust. So it does become its own kind of functioning entity. It's that the trigger mechanism for that functioning entity is embedded in your will, as opposed to option 2. You've already created a standalone set of commands for that trust.
Got it. Okay, so yeah, I'm in my life, I am establishing one that then would pass on, whereas in the other one, in my death, it triggers this set of events that now it's Tom's problem to go figure out if he's going to pick Wells Fargo or Bank of America and all of those other decisions. So it really seems like the importance of picking somebody who's like pretty financially literate and is, pretty tech savvy. There's like a category of characteristics of somebody that isn't just somebody we trust. They need to be somebody we, not in the way you're using trust, that somebody we're willing to put our faith in, but somebody who also is pretty competent in navigating some of these things as well. Does that sound right?
Trustee selection is a big deal. And I think I have the next slide on it. What should these things do? Choosing an executor or choosing a trustee. Trustee is the more important of the two. Ultimately, if we're going to have someone, we want some financial literacy. I really like, there's probably a whole, class that could be taught on this. You want someone who, if not possessing the financial literacy or sophistication that you would prefer, is humble enough to seek out those sources to surround him or her. And so I think a good trustee can make up for those deficits. But if you had all the marbles that you wanted, it would be a trustee who had that financial literacy. I give you an example. I have the co-trustees on the Cressman Family Living Trust would be one of the lawyers in our office and my brother as co-trustees, because I thought together they kind of had the pieces, so I named them both. So you could kind of think about if not one trustee, then multiple trustees who complement each other and who could operate well together. So everybody does need a will. There's no two ways around it, especially if you have spouse, young children. It's really critical. Make sure that it actually clearly names beneficiaries, names your executor, names guardians for those children. Very simple sentence. Pick trustworthy people for who you want to have physical control of your children if something happened to you. Number 2, sometimes what those things needed, or what those wills need to do, are establishing trusts as well. Just looking at Shane's question here, someone who understands what you want for you. Yeah, someone who shares, and to Shane's point, that's kind of why I named 2 people to mind. I wanted to make sure I had people whose values in terms of what the children needed reflected my own. You can put in some mechanical provisions in your will or your trust to direct how you want your trustees to handle distributions to children. But ultimately it's going to be a person making those calls. Make sure your will directs assets as is desired in a given situation. So the 3 steps I would give you from a takeaway standpoint, please make your list. Make it before you go into the lawyer's office. You'll know kind of what's going on with your estate plan if you can generate that list prior to actually going in and seeing the lawyer. Number two, and I'll get to your question here, Shane, in just a moment. Number two, ultimately take some action, find a lawyer in your state, bring your list with you, talk clearly about the desires you have. It helps if you go in and you and your spouse, if you have one, have already agreed upon who you wish to be guardians of your children and who you want to be responsible for the assets you're leaving behind for your children. Who are my trustees? Who are my guardians? That's what my buddies who say, can you do my will really quickly? And I say, okay, here are the 5 questions. I don't need to know that much, but I do need to know who you want to leave your children to. Shane had a nice question. How do you vet an estate planning attorney in your state and your area? You can ask for recommendations. You can look for online reviews. Those are never bad indicators. I can say, having read the online reviews for my establishment, they're not always the best guidance. It's really hard to tell. A lot of my clients are elderly. They don't use the internet. So I have like 0 online reviews, despite the fact I do, 1,000 or more wills every year. So it's a little bit tough. The good news is, in most situations, straightforward dispositional planning is not that hard. And so the good news is, even if you don't like the lawyer or they overcharge you, you're probably going to get something that is functional and suits your needs. It is a real question. I don't have great answers for you. If I met with a lawyer and I didn't like him or her after about 30 minutes, I wouldn't hesitate to pull the plug on the appointment, as hard as that can be. You could see. I also look at cost. This frustrates the living daylights out of me. So I practice in Northwestern Pennsylvania. It's a more rural sort of market. We charge $300 to do the thing that I am talking to you about. Now, if you had a revocable living trust, we'd bump that up to like $750. Be wary. The further you get into 4 figures, if you do this in San Francisco, it's going to be more money, or if you do this in Boston, it's going to be more money. But I had a couple friends of ours who were doing this up in New York, and the routine quotes they were getting for young person planning was like $3,500. Maybe that's the going rate. But that's a lot of money to do what is frankly pretty simple here. No, I don't have good answers for you in that regard. Price matters. Look around, talk to people in your community. That's harder as we become more disconnected. I live in a small community, so the same people you see in the grocery store, you see in church. And so you can say, how is so-and-so? Think about what your community means in terms of people who live locally to you, and try to get some answers there. That's an important question. I just wish I had a better answer for you, frankly. Next steps, number 3. This is the most important thing. Make sure your beneficiary designations are done, are correct, and update them every single year. If you wanted to be a real ninja with this, you make that list that I talked about, you do your estate planning documents, keep the list with your estate planning documents, and keep your estate planning documents somewhat proximate to your will or to your tax returns every year. Every year when you do your tax returns, look at your list, see what has changed, and remember, if you have to update something, you are young, you are going to accumulate new assets, those assets are going to grow. You're going to close accounts. Things are going to change every year. If you want to do this right as a parent, as a spouse, you really will just make that part of the checkup that you do every single year. It's really, really hard to do. So if you do that, you're ahead of the pack. And those are all the slides I have. I'm sorry, I was kind of hoping this would only be 30 minutes. I got carried away. Anyway, I'm still here for another half an hour if you have questions. So
no, Ty, this was great, and I want to be respectful of your time. I have a list of questions. I'll probably follow up, and maybe if you have time, we can do a part 2. But is there a way that our team could contact you if we have some questions before we find our own local option?
Sure, you can, and feel free. I've emailed Morgan over the last little bit. Feel free. You can share his, Morgan. You can share my email with whomever you want. You can also go to our website. Please be gentle. I made it myself when I was 27 years old, and as I've said, I do not have a tech background, so it's very basic. You can get chuckle out of it. But that also has all of my information and maybe some information that might be valuable as well. Um, the Feel free to email me whatever you need. I'll try to be quick. If you copy Megan, that's a nice additional security to make sure that you get a response. And so, and if you don't get a response in 2 or 3 days, email me again. I'm a small business owner, so I get caught up on things from time to time. So don't just email or re-email. I'm always happy to help anyone with a news story. I support the mission that you are working on. You've been very good to my wife, so I'll be helpful to any of you to the extent that I can. So.
Awesome, Ty. Well, appreciate it. I'll pass along your info to the group. And I know I have lots of notes here. If anybody else wants to drop some of their notes into our channel in Slack, I think that would be great. And yeah, we'll be in touch soon.
Awesome. Have a nice day, guys.